our submission, obviously, is that sexual orientation is not an immutable trait, that it is an accident of birth.
Accident of birth?
Well, yes, Your Honor. Sex, your gender.
It can be changed
here
before,
about the.
Can be changed before birth, but not after birth. What do you mean? It's an accident of birth?
Accident of birth, in the sense that the term has been used consistently by the Supreme Court to identify the kinds of immutable characteristics that that go into the calculus on whether heightened scrutiny should apply. Political powerlessness, immutability, and history of discrimination. Essentially, the three principal issues.
And religious discrimination, of course, is prohibited. It's one of those fundamental rights subject to strict scrutiny. If the state imposes some limitation on classification based on religion, and religion is certainly not an immutable characteristic.
That's true, Your Honor, but we would submit that the heightened and strict scrutiny that is accorded to religious classification springs not from the Equal Protection Clause, but from the First Amendment. And we think that Davey against Locke supports that proposition. We don't. We believe that the areas that the Supreme Court, at least thus far, has identified as qualified for heightened scrutiny have been race, of course, the central concern of the 14th Amendment, which, by the way, I forgot to mention when we were discussing Loving. But that, too, was a key point, and one that the court repeated. The Loving court repeatedly made, was that the central concern of the 14th Amendment was to eliminate all invidious racial discrimination. And obviously, here that is not the case. But to come back to the immutability issue, the Ninth Circuit in the high-tech gays case said, unequivocally, sexual orientation is not an immutable characteristic. I think that's the quote. And, Your Honor, measured against the Supreme Court's decisions, we submit that is plainly right. And again, we are aware of no case that has held heightened scrutiny under the Equal Protection Clause or anything else applies to a sexual orientation classification. Every case holds to the contrary. And specifically on the immutability issue, the record before you is really quite overwhelming, that the characteristics of immutability simply do not apply with respect to sexual orientation. Not only is it difficult to define, as almost all of the plaintiff's experts testified to, there are at least three definitions: the behavioral-based definition, the attraction-based definition, and the self-identity-based definition, that depending on which one you use, there's a wide variety of the people who are within that class. Beyond that, Your Honor, and not just its amorphous and difficult definitional situation, is the fact that the plaintiff's witnesses were quite candid and unequivocal and uniform that sexual orientation does change. It does change over time, and it apparently changes especially in women. There was testimony from Dr. Peplau about the astonishing plasticity of sexual orientation in women, and that men and women experience a change in their sexual orientation several times over the course of a lifetime. But perhaps the most, I would think, vivid evidence was an APA study which indicated that over a 10-year period, For women who identified themselves as homosexuals, some 2/3 of them had changed their sexual orientation essentially, had experienced themselves a change in their sexual orientation at least once over the course of their lifetime, and a third more than once. And this goes directly to the Supreme Court's test of immutability. Is it an accident of birth? Here's what Justice Ruth Bader Ginsburg said about this test. The immutable characteristic notion, as it appears in Supreme Court decisions, is tightly cabined. It is a trait determined solely by the accident of birth. And here, Your Honor, the traits or the characteristics that have been determined to be immutable and to qualify for heightened scrutiny by the Supreme Court have been things like race, which is obviously determined at birth. It's, quote, an accident of birth, gender, and illegitimacy. And as Judge Ginsburg also said, it doesn't mean it's something that can be changed, but it is something that is...
Is it national origin also one of those?
Yes, Your Honor.
And
yes, Your Honor.
People, I don't know whether they change their national origin on St. Patrick's Day. Everybody's Irish.
I've experienced that change myself.
And people can look to one ancestor and suddenly become that, or another occasion pick another ancestor and maybe even invent an ancestor. So these immutability characteristics, they really are not the important factor, are they, in deciding what the level of scrutiny is?
Well, Your Honor, yes. With respect, it is a critical element, but it isn't more or differently critical than, say, political power. And, Your Honor, under the Supreme Court's test for political powerlessness, we would submit to you again that the evidence is overwhelming that gays and lesbians are not particularly powerless, notwithstanding Dr. Segura's testimony, which we believe advanced to the court a test for judging political powerlessness that just simply has no basis in the legal principles that this court is bound to apply. The legal test from the Supreme Court was stated clearly in the Claiborne case as does the group, they're the mentally disabled, does the group have the ability to attract the attention of the lawmakers or of the decision makers attract the attention? In high-tech gays in the Ninth Circuit, the court said that gays and lesbians 20 years ago, gays and lesbians are not politically powerless because they clearly have the ability to attract the attention of the lawmakers. And that was that was 20 years ago, Your Honor. And since that time, as I think all of the plaintiff's witnesses acknowledged, there's been just an extraordinary evolution. I think Dr. Chauncey used the word sea change in the attitudes and acceptance of gays and lesbians and in their political power, especially as reflected in the extraordinary difference in the legal landscape between today and 20 years ago with respect to protections.
Isn't that the most important factor, that is the historical context, in that women are hardly politically powerless? They're a majority of the population, probably a majority of the voters. They have considerable political power, and yet a law which classifies women in some fashion differently from men is subject to strict scrutiny. African Americans are hardly politically powerless, and they've had an enormous political gains in the last 50 years or so, and yet laws that single them out from others would be subject to strict scrutiny. Isn't it that it's the historical context that determines whether or not strict scrutiny is appropriate for a particular classification more than political power factor or the immutability factor or these other factors? Isn't that what really decides the issue?
Your Honor, I think it is I think it is an interesting, different and perhaps in some ways difficult question whether or not, for example, women whose political power and whose positions of political and positions holding and exercising political power has changed so dramatically since Reed against Reed in 1971 and Frontiero in 1973, when the court first concluded that gender is a quasi-suspect classification regarding an intermediate level of scrutiny. At that time, when the court had before it in this question and whether or not political powerlessness of the group suggested that they needed extraordinary protection from the majoritarian political process that only the courts could provide, at that time, Your Honor, women were still effectively 50% of the population. But they held like 2% of the elected offices in the country. As the Frontiero court said, it was a minuscule percentage. I'm not sure it was 2.
Legislative facts, I assume.
Yes, yes, Your Honor, absolutely. That is not the case, certainly in California, not in California with respect to lesbians and gays. So I do believe that the...
Isn't Proposition 8, these other propositions in other states that limit marriage to opposite-sex couples, the DOMA statute that's been mentioned, the exclusion of gays and lesbians from military service for a long period of time, aren't all of those simply indicia of a long history of discrimination?
Your Honor, we would... I want to be clear on this. We have never disputed and we have offered to stipulate that gays and lesbians have been the victims of a long and shameful history of discrimination. We have been bound to note that. Thankfully, the situation today in 2010 is not what it was even yesterday, let alone in 1990 when high-tech gays was decided, thankfully. But it isn't adequate. The fact of a history of discrimination is not by itself sufficient to warrant heightened judicial scrutiny. The court has always insisted as well on immutability of the characteristic and political powerlessness at the time that the issue comes forward to the court. The question of political powerlessness, yes, it would have been different, very different if it was very different 20 years ago on high-tech gays, very different. But the Ninth Circuit nonetheless believed that gays and lesbians could attract the attention of lawmakers even then. If that was true, it follows undebatably that it must be true today. And the court in the Claiborne case held that even though the mentally retarded had suffered a history of discrimination in many respects, and even though mental disability is immutable, the mentally disabled nonetheless couldn't qualify for heightened scrutiny, and only rational basis review applied on classifications drawn there, because the mentally disabled had political power. They could attract the attention of lawmakers. And obviously, they had to rely to attract the attention of lawmakers on allies, not on their own resources, their own political muscle and their own numbers, but had to rely upon others who allied with their interest to create that political power. And, Your Honor, if they weren't politically powerless, and that case was decided, I think, in 1987 or so, just a couple or 2 or 3 years before high-tech gays was decided. So, Your Honor, if they didn't qualify, it was not a close call, I would submit to you. In the Ninth Circuit, in high-tech gays, and it's certainly not a close call today. So our submission, Your Honor, is that with respect to heightened scrutiny under the Equal Protection Clause, the courts that have uniformly decided that this case against the application of heightened scrutiny have been correct.
I want to ask you about something, but go ahead.
Well, I'm trying mentally here to assess where we've been and what I have in front of me, and but I'm trying to respond as best as I can to your questions, Your Honor.
Fair enough. Mr. Blankenhorn, why should Mr. Blankenhorn's testimony be admitted? Does he meet the Dober standards?
Your Honor, I submit to you that he does. By the way, I didn't understand your earlier ruling to be accepting him as an expert to have been provisional. But the court has, I think, in its questions clarified that. But I really don't have anything to add to the submission we made with the motion in limine was before you, or with the voir dire took place and the motion in limine. I would say, Your Honor, that under the Ninth Circuit standard for the qualification of an expert, Mr. Blankenhorn is amply qualified. I believe amply qualified, I submit to you. His professional life for 20 years has been devoted to the study of one subject, the subject of marriage, the subject of the potential and parenting structures and the potential for harm to marriage from a variety of social phenomena, including now same-sex marriage. He's written 2 books on the subject matter, which have been the product of deep study and wide study. Those books have been received with respect by recognized experts, including Dr. Lamb.
Were they peer-reviewed?
The book?
Yes.
No, Your Honor, no.
In fact, am I correct that the only peer review writing of Mr. Blankenhorn was not on the subject of this litigation?
Your Honor, as I stand here right now, I can't answer that.
All right, fair enough.
I can't, but Your Honor, I think the Ninth Circuit Court's standards for qualifying an expert are particularly liberal. And I don't think they require, they certainly don't insist upon that an expert's publications have been peer-reviewed. That's an element, but it's not a mandatory one. So, Your Honor, again, I didn't really come
All right.
Here prepared to particularly re-argue that, but I do believe that the transcript provides all that I had to say with respect to that issue.
All right. Well, if in the cool light of the morning you want to submit anything further on that, I'll be happy to give you the opportunity.
Thank you. I appreciate that. Thank you very much. Would the court entertain,
A break?
Maybe 5 minutes?
Sure, of course. Why don't we take a little more than that? Resume at 10 minutes after the hour, and we'll finish with Mr. Cooper for maybe 20 minutes, and then...
At most, Your Honor, at most, if I can hone in.
And who's going to rebut for the plaintiffs? Mr. Olson. All right, Mr. Cooper, carry on.
I appreciate the court's indulgence.
Well, it was a good idea.
Your Honor, I hope I have sharpened my thoughts a little bit here as my closing argument comes to a close. I want to address an issue that the court took up with Mr. Olson, and that is the question whether or not this case would have been different in the California Supreme Court had not rendered its ruling when it did, and or maybe even stayed the application of its ruling in anticipation of the people's judgment of Proposition 8, as it was asked to do, and has, as some other state Supreme Courts have done in similar circumstances. This is something which I agree with, on which I agree with Mr. Olson, if I understood his answer correctly. I don't believe that would make a difference. I don't believe that the fact that the California Supreme Court rendered its ruling and that it was effectively overturned by the vote of the people should make a difference either in the analysis of the case. The court, I think, asked Mr. Olson what kind of regime would we have if the constitutionality of California law prescribing the traditional definition of marriage would be would turn on whether or not the issue came to a federal court before or after the state court had decided the issue. And, Your Honor, the United States Supreme Court has addressed precisely that circumstance in a case called Crawford versus Board of Education. I want to share a passage from that case. It was from 1982. It upheld a California constitutional amendment that reduced the remedial tools that were available to state courts in the school desegregation area. It cut back on those remedial tools, and in that case, the court stated as follows. We reject the contention that once a state chooses to do more than the 14th Amendment requires, it may never recede. They reject an interpretation of the 14th Amendment so destructive of a state's democratic processes and of its abilities to experiment. This interpretation has no support in the decisions of this court. And, Your Honor, the court went on, and it was as though I would submit to you, it had this case in mind when it further said, we would not interpret the 14th Amendment to require the people of a state to adhere to a judicial construction of their state constitution when their constitution itself vests final authority in the people. In short, having gone beyond the requirements of the federal constitution, the state was free to return, in part, to the standard prevailing generally throughout the United States. Your Honor, one of the points that the Crawford Court makes...
What do I make of that in this context, in this case?
That essentially the California Supreme Court's interpretation, which we would submit goes beyond the 14th Amendment, was something that the people of the state were empowered essentially to reverse. And that is especially true. That's especially true given the fact in California, and Crawford came from the state of California, the people of the state reserve into their own hands as essentially the ultimate appellate tribunal in this state, the authority to review the decisions effectively of the California Supreme Court. So, in a very real sense, the California Supreme Court's decision, particularly given the Proposition 8 was then effectively pending before the people, the California Supreme Court's decision was, in that context, no more final in the state of California than the California Court of Appeals decision was before that, which had upheld Proposition 8 by a closely divided court. It was reviewed by the ultimate judicial tribunal in this state, and the judgment of the Supreme Court in the Crawford case, it seems to me, is on the point here. Your Honor, I want to address, I think, finally here, the issue of whether or not there's a legitimate basis for people of this state or anyone to be concerned that redefining marriage, redefining the traditional understanding of marriage to include same-sex couples presents any basis for concern about the harm to marriage that may result, and to the interest that the institution of marriage has historically been designed to advance. Many people believe, Your Honor, that harm will, that such harm is threatened. But before analyzing this, I think we have to begin with two propositions. The first one is that redefining the institution will change the institution. I think Mr. Blankenhorn really summed it up quite well. If you change the definition of a thing, it's hard to imagine how it could have no impact on the thing itself. The plaintiff's experts acknowledged, the plaintiff's expert and others have thought and are expert in this field, have acknowledged that change will result. Indeed, when same-sex marriage was legalized in Massachusetts, Professor Cott commented, one could point to earlier watersheds, but perhaps none quite so explicit as this particular turning point. Professor William Eskridge of Yale Law School and a leading advocate for same-sex marriage has said that enlarging the concept of marriage to embrace same-sex couples would necessarily transform it into something new. Joseph Raz, who was a professor at both Oxford University and Columbia Law School and a same-sex marriage advocate, stated this: "There can be no doubt that the recognition of gay marriage will effect as great a transformation of the nature of marriage as that from polygamous to monogamous, or from arranged to unarranged marriages." Same-sex activist E.J. Graff of the Brandeis University wrote, "If same-sex marriage becomes legal, that venerable institution will ever have to stand for sexual choice, for cutting the link between sex and diapers." That really goes to the heart of the concern of many people, that redefining it will effectively divorce the institution of marriage from its historic core procreative purposes. The second point, Your Honor, in addition to that redefining it would inevitably change it, is that it is not possible to predict with certainty and confidence what that change will beget. It seems simply undeniable that a change that is as profound as this one, I would submit undeniably, would have some consequences. And the plaintiffs think that the consequences dominantly will be good consequences. And again, we respect that point of view, but it's not something that they can possibly prove. And their own expert agrees. Professor Cottigan said this: "The consequences of same-sex marriage are impossible to know because no one predicts the future that accurately." Andrew Cherlin, who's a sociologist at Johns Hopkins and a supporter of same-sex marriage, has written, and you will remember his name from the trial, I'm sure. He was the subject of a lot of discussion when Mr. Blankenhorn was on the stand. He's written that predicting the future of marriage is a risky business. And he remarked about the unimpressive record of social science researchers in predicting cultural phenomena. He says, often and perhaps even most of the time, they get it right. But sometimes they are spectacularly wrong, as he said. For example, in the 1930s, every demographic expert in the United States, every demographic expert, confidently predicted a continuation of low birth rates of the Depression. No one forecast the baby boom that overtook them after World War I. Similarly, not a single 1950s or 1960s sociologist predicted the rise of cohabitation. Two extraordinary sociological phenomena, Your Honor, that no one had a clue was coming. In this circumstance, and we would submit to you, and I would add this because I have heard this and read this more than any three things, three words that I have ever spoken, I don't know. I don't know how many times, Your Honor, I had wished I could have had those words back.
Well,
because, Your Honor, whatever your question is, I damn sure know whatever it is.
what do you make of Mr. Blankenhorn's statement that when same-sex marriage is legalized, that America will be more American and will be closer to the American idea? That was your own expert.
Yes, Your Honor. Yes, it was. And I think Mr. Blankenhorn was giving voice to a sentiment. And Mr. Blankenhorn shares that sentiment with many of my friends for the plaintiffs. And I think he shares that sentiment with many of my fellow Americans. But he believes that the threat of harm to a central and vital social institution, marriage, and to the interests that he believes that it serves, is too daunting to run the risks of gratifying what would otherwise, for Mr. Blankenhorn, favor, no doubt, as he has said, that the advent of same-sex marriage. And, Your Honor, I believe that there are many who went in the polling place with that sentiment. That's my speculation. That's all it can be. But as Rabbi Michael Lerner has said, a well-known person and certainly an advocate of same-sex marriage, there are millions of Americans who believe fervently in equality for gays and lesbians, but who draw the line at marriage. Their hearts are, as I would submit to you, pure as defined by the plaintiffs. But they still believe this is profound. This could be profound. It could portend some social consequences that would not be good ones. And, Your Honor, that reality, the reality that I didn't know because no one can know, Professor Cott doesn't know, Blankenhorn agreed it's impossible to be completely sure about a prediction of future events. There has never been anyone who knows what tomorrow will bring. But if there's a legitimate and rational basis to be concerned about that, it couldn't be more rational for the people of California to say, we aren't going to run that risk, however we assess it. There's a risk, and we are going to wait. We want to see what happens in Massachusetts. We want to see what happens right here and elsewhere. And perhaps Mr. Olson and his clients whose sentiments, you know, are powerful will be able to convince their fellow Californians that, in fact, they're right and this should happen.
A disability, a classification, has been put on marriage which disables people who wish to marry others of the same sex. In order to disable certain citizens, do you not have to show a correlative benefit to others or to society? And the I don't know, we don't know where it's going to lead answer, is that enough to impose some citizens a restriction that others do not suffer from?
Your Honor, it is, if there is a rational basis for that distinction, yes. I really think that really ends up being the bottom line on it. If there is no, in looking at whatever society's purposes are for marriage and interests are for regulating and caring about marriage, if there's no basis on which to draw a distinction between one group and another, then the distinction can't stand. If there is a distinguishing characteristic that is relevant to one of those purposes, then the distinction can stand. And so you know, as we have been, has been our position from the beginning, we don't have to prove that including same-sex marriage within the definition or redefining marriage to include same-sex marriage would visit harm upon the institution and the interests it serves. We submit to you that it is not something that is our burden. And I think that's what your correlative benefit question goes to. Rather, we have only to prove that including same-sex couples would not serve those interests, either at all or not to the same extent. And we believe that, you know, the Supreme Court's case, in particular Johnson against Robeson, is particularly specifically on the point of that, as much as essentially in those terms, Your Honor.
I'll let you wrap it up.
Yeah, so the California Court of Appeals in the marriage cases, as I mentioned earlier, and as the court well knows, actually upheld the traditional definition of marriage in that case. And one of the points it made, Your Honor, I think really goes to the heart of the matter, and certainly to the heart of our submission, in that it is the proper role of the legislature, not the court, to fashion laws that serve competing public policies. The legislative process involves setting priorities, making difficult decisions, making imperfect decisions, and approaching problems incrementally. That process is what is at work in this state. And it's at work elsewhere in this country. And as the court in Glucksburg said, there is a debate about the morals, the practicalities, and the wisdom of this issue that really goes to the nature of our culture. And the Constitution should allow that debate to go forward among the people. Thank you.
Thank you, Mr. Cooper. Mr. Olson, why don't we just begin at that point that Mr. Cooper just left off with? And that is, in a sense, isn't the danger, perhaps not to you and perhaps not to your clients, but the danger to the position that you're taking is not that you're going to lose this case, either here or at the Court of Appeals or at the Supreme Court, but that you might win it. As in other areas where the Supreme Court has ultimately constitutionalized something that touches upon highly sensitive social issues and taken that issue out of the political realm, that all that's happened is that the forces, the political forces that otherwise have been frustrated, have been generated and built up this pressure and have, as a subject matter that I'm sure you're familiar with, plagued our politics for 30 years. Isn't that the same danger here with this issue?
I think that the case you're referring to has to do with abortion.
It does indeed.
And the cases upon which we rely, in which the courts have responded to the needs of the civil rights of our citizens, have been entirely different cases. They have relied on, as we do, fundamental established constitutional law. Because the arguments that Mr. Cooper makes is essentially the same argument that was made in the Loving case, which, by the way, the Loving court unanimously decided to strike down 14 or 15 miscegenation statutes. California had been the first 20 years before that. When it got to the Supreme Court in Loving, it became unanimous. And we stand here today thinking, how could that have been? In 1967, that's only 40 years ago, we would have punished as a felony in the state of Virginia the president's mother and father if they had tried to travel there and be married. The same argument was made to Martin Luther King and to Thurgood Marshall and to Ruth Bader Ginsburg. We're talking about fundamental constitutional rights. We are talking about treating people equally. That's not breaking new ground. We're talking about allowing people the same freedom to marry the person that they love as we have the rest of our society. Now, Mr. Cooper's argument is, and I know he would like to take back these words, and I know why he would like to take back these words. We don't know. We don't have to prove anything. We don't have any evidence. Yet he relies on persons. He was reading from articles written by various persons just a few moments ago from this podium who did not come into this courtroom and testify under oath and subject themselves to cross-examination by my colleague, Mr. Boyes. Some of them didn't come into the courtroom because they'd been cross-examined by Mr. Boyes in their deposition. But you have to know, you can't take away the rights of tens of thousands of persons. These rights were recognized and did exist in California. I submit that they should have existed before the California Supreme Court decision and before Proposition 8. But you can't come in here and say, I don't know, and I don't have to prove anything, and I don't need any evidence except for some people writing in books who won't come into court and subject themselves to the judicial process. You ask very good questions. I was about to start with it. Mr. Cooper talks about procreation as a fundamental basis for marriage. And you made the very good point. Well, don't you have to prove that Proposition 8 does something to protect procreation? The channeling, what Mr. Cooper calls the channeling function, which is a new term for me today, that the state of California is in the marriage business in order to channel us, or those who are unfortunate enough to live in California get to be channeled. But he does have to prove, the Romer Court specifically says this, under the lowest standard of review, you have to prove that you have a legitimate interest and that the object Proposition 8 in this case, advances that legitimate interest. So how does preventing same-sex couples from getting married advance the interest or protect the interest of procreation? They're not a threat to us. What one single bit of evidence that they are a threat to the channeling function? If you accept that California has the right to do that in the first place, and I do not, this is an individual constitutional right. And every Supreme Court decision says that it's a right of persons, not the right of Californians to channel those of us who live in California into certain activities or in a certain way. What do you have to do? What do you have to say that Proposition 8 somehow protects this thing that's going to happen? Mr. Cooper finished up by saying, well, you have to admit my traditional definition of marriage, which was not the definition in 14 Supreme Court decisions. It wasn't the definition of Dr. Cott. It wasn't the definition of Dr. Peplau. We had expert witnesses that talked about the history of marriage going far back. Not 30 years, but far back into history, what marriage has always been. The Supreme Court said older than the Bill of Rights, older than our political parties. That's not something new. It's marriage. It's not single-sex marriage or interracial marriage or anything like that. Mr. Cooper says that you have to accept the fact that, first of all, you have to accept my definition. It has to be between a man and a woman. Then, if you have a marriage between a man, or a woman and a woman, it will change the marriage. Well, of course it will, because you started by defining the term that you wanted to define. What we're talking about here is allowing individuals who have the same impulses, the same drives, the same desires as all of the rest of us, to have a relationship in harmony, stability, and to form a family and a neighborhood, all of those things that the Supreme Court talked about. And now, tell me how it helps the rest of the citizens of California to keep them out of the club. It doesn't. Now, this so-called deinstitutionalization that Mr. Cooper has talked about a lot earlier, not so much today, but he has talked about it, the breakdown of marriage. It turns out that Mr. Blankenhorn talked about that during the trial as well. And I want to just play, I'm just going to do 2 more short clips from Mr. Blankenhorn. Mr. Cooper wanted him to stay as an expert in this case, and we'll accept that because he turns out to be fairly helpful to us. But he talked about this deinstitutionalization of marriage. And if we can pull the right switches, hear what he had to say.
And I meant to say, just for our purposes today, heterosexuals, heterosexuals did the deinstitutionalizing. I mean, if we go back and look at the trends I described, it's very clear that this was not... Deinstitutionalization is not something that just cropped up a few years ago whenever we began discussing the possibility of extending equal marriage rights to gay and lesbian people. It predates all of that.
And Dr. Cott pointed out the increase in marriage, decrease in marriage, the increase in divorce, the increase in cohabitation happened all over the world between 1970 and 1985. One of it was the institution of no-fault divorce. New York is considering no-fault divorce now. It will be the 50th state to adopt no-fault divorce. So much for the channeling function in those 50 states. But the point is that the so-called breakdown of certain aspects of marriage, as Mr. Blankenhorn admits and testifies under oath, and good for him, he did come here for cross-examination, was a product of the breakdown of the heterosexual marriage. It didn't happen because someone in the California Supreme Court decided that this is a right that cannot be withheld from individuals. As far as raising children in a happy, stable environment, here is the last clip from Mr. Blankenhorn.
And you were not meaning to imply, were you, that biological parents were any better parents than adoptive parents?
No, sir.
In fact, the studies show that all things being equal, two adoptive parents raising a child from birth will do just as well as two biological parents raising a child from birth, correct?
No, sir, that's incorrect.
Well, sir...
May I say another word on that, please?
You will have an opportunity on redirect.
Okay. It was a clarifying thing and actually supports something you just said. The studies show that adoptive parents, because of the rigorous screening process that they undertake before becoming adoptive parents, actually on some outcomes outstrip the biological parents in terms of providing protective care for the children.
Well, there you have it. There's 37,000 children in same-sex families in California. According to Dr. Blankenhorn, they are better off, perhaps, than in opposite-sex marriages. Now, maybe they are not, but all of the evidence was that they would not be in any worse. Several of the evidence, much of the evidence, suggested these children are in happy relationships. And Mr. Blankenhorn also suggested that when marriage is legalized between their parents, they will be better off still. Now, it is important to say another word or two about procreation and whether or not it's a state's interest. I mentioned this before, but I want to emphasize it. If it's the state's interest in procreation that animates the right to marriage, what if the state changes its mind? There have been cultures throughout the world that have decided we've had too much procreation. We have too much population growth. What if the state of California decided 10 years from now, we don't want so many people in California? Would they be able then, I don't think anyone would agree that the state could then cut off the right to marry, because it is an individual right to privacy, liberty, association, and that's what it is. So the state can't put the switch on and the switch off because it's not the state's right. It's the individual's right. We mentioned the 14 Supreme Court cases. None of them said, including the one that Mr. Cooper mentioned over and over again, the Maynard case, none of them said it's the state's interest in procreation. And those cases included where they were talking about the fundamental right to marriage. They talked about the fundamental right to marriage as an individual right in the context of contraception, which is not procreative. Interracial marriage, which is neutral on the subject. Divorce, which is not channeling somebody into a relationship. Mandatory leave for public school teachers. Family occupancy of a particular family home. Prisoners, and so forth. Abortion even. Including the last case, Lawrence v. Texas, which talked about it in the context of the rights of homosexuals to seek autonomy in the same right for those decisions, the same right for these decisions, just as a heterosexual person may do. And Mr. Cooper twice or three times cited Justice Stevens, the minority in the Bowers v. Hardwick case. It turns out that Justice Stevens, in his dissent in Bowers v. Hardwick, is quoted in the majority decision in Lawrence v. Texas. So the same authority that Mr. Cooper was relying on says this on page 578 of Lawrence v. Texas. His dissent in Bowers is placed on the record and a part of the majority in Lawrence. Individual decisions by married persons concerning the intimacies of their physical relationship, even when not intended to produce offspring, are a form of liberty protected by the Due Process Clause of the 14th Amendment. Moreover, this protection extends to intimate choices by unmarried as well as married persons. That's the oracle of Justice Stevens, confirming the point of all the witnesses that have talked about that in this case, the expert witnesses, Dr. Cott, Dr. Peplau. And so that is not the definition of the institution of marriage. And Proposition 8 isn't changing the institution of marriage. It is correcting a restriction based upon sex and sexual orientation. You asked the question, and I'll be brief on this, what happened in California or throughout the United States? Why have things changed with respect to, why are we all of a sudden talking about same-sex marriage? Several of our witnesses talked about the fact that the history of discrimination that no one denies has improved. It's ameliorated. It's no longer against the law to work for the federal government. It's no longer against the law in most places to walk into a bar if you're a homosexual. The breakdown, thank God, of some of those barriers has changed people's attitudes. And I'm sure that contributes to people saying now, well, if that's the case, and psychiatrists have changed their view about homosexuality. People no longer think it's a disorder or anything like that. They've explained, and people have begun to understand the differences between various members of society. And we found out that all of those horrible taboos are not justified in fact. And the stories, some of which were on the ads which were supporting Proposition 8, are no longer true. So, of course, people are thinking, well, if these are our fellow citizens and they don't represent a risk to us, they are not damaging, they are just like us, why shouldn't we start talking about marriage? You talked a bit about the Loving case and the change that occurred there. 41 states, it wasn't just a Southern thing. It wasn't just in the South. It was 41 states at one point had a prohibition on interracial marriages. And the proponents of the change in that case said that this is going to change the traditional definition of marriage. It's going to weaken marriage, and the Supreme Court brushed that aside.
But in 1967, it wasn't 41 states who had those restrictions.
No, it was about 14 or 15 in 1967.
14 or 15?
But it had been at one point 41 states.
All right.
And California broke the barrier 20 years before Loving.
So some 27 states removed the restriction.
And that first one, the ice was broken by a court decision.
I fully understand. But there was already a tide running, a political tide running with respect to interracial marriage. And as Mr. Cooper duly commented about the Supreme Court took note of that. Now, do we have a political tide here that's going to carry the Supreme Court?
I believe, Your Honor, that there is a political tide running. I think that people's eyes are being opened. People are becoming more understanding and tolerant. The polls tell us that. That isn't any secret. But that does not justify a judge in a court to say, I really need the polls to be just a few points higher. I need someone to go out and take the temperature of the American public before I can break this barrier and break down this discrimination. Because if they change it here in the next election in California, we still have Utah. We still have Missouri. We still have Montana. This case is going to be in a court. Some judge is going to have to decide what we've asked you to decide. And there will never be a case with a more thorough presentation of the evidence. There will never be a case with such a wildly crazy system that California has. There will never be a case more like Romer, where the right existed and then it was taken away. There will never be a case against this background. The Supreme Court really made that step that you are talking about in Lawrence v. Texas. And that overruled Bowers v. Hardwick, which was only 20 years earlier. But that broke the barrier by saying that the behavior, the conduct between the individuals is a right of privacy, and it's protected by the Constitution. And the right of privacy is the same right that we're talking about in the context of marriage. And I don't think that it is justification for waiting any longer. And as I said, the most compelling thing that I have read on that subject was the arguments that were being made to Martin Luther King saying, you know, you ought to ease up. The people aren't ready for these kind of changes. There's going to be a backlash. and his letter from a Birmingham jail explaining why he could not wait to press the civil rights of his fellow citizens is as compelling a statement on that subject as has ever been written. Now, we talked a little bit about, Mr. Cooper came up with something that I hadn't really heard about until the closing arguments in this case. I really don't remember the evidence. The threat of irresponsible procreation. I tried to figure out what that means because the clients I represent don't represent a threat of irresponsible procreation. I mean, they are interested in getting married to someone of the same sex. Mr. Cooper acknowledged that they are not a threat of irresponsible procreation. On the other hand, heterosexual couples who practice sexual behavior outside their marriage are a big threat to irresponsible procreation, if that's what it's all about.
Heterosexuals that have led to the deinstitutionalization of marriage, heterosexuals that have...
That's right. And people will run out and, yeah, well, that's it. But we don't have the proof of it, and we don't know what will happen. And the experts said that it wouldn't happen, and the experts said that marriage would be stronger. But the one thing we do know, unless you believe that allowing them into the institution, you're going to have all these heterosexual people running out and engaging in extramarital conduct, that is not going to happen. That is not the evidence in this case. And just because a lawyer says it in here doesn't mean it's true. We have evidence. We have a 3-week trial that demonstrates it. We had a short discussion about the motivation of the voters. You asked a question.
Right.
And was the procreation protection a goal, and was the procreation protection goal a part of why the voters voted for Proposition 8? Mr. Cooper cited 2 examples. Well, he cited 3, the voter pamphlet. And I'm going to come back to that. He cited PX 97 and PX 27. While I was sitting here, we looked at those exhibits, and they do have to do with men and women, but they don't mention procreation. So that wasn't put before the voters in those 2 documents. I hope I'm not mistaken, but I'm quite certain that we looked at those, and that's the answer to that. Okay. As far as the ballot, the official ballot pamphlet is concerned, here is the argument. This, I think, was Exhibit 1 in this case, and there's about 6 paragraphs of arguments about why Proposition 8 should be adopted. I just did a hurried look. I couldn't find the word procreation, but I did find the words activist judges. But the words that I found the most were protect our children. They are in here about 5 or 6 times in those 4 short paragraphs. Protect the children from learning that gay marriage is okay. That is to say that gay people are okay. The motivation for the adoption, if there's one thing that would have more significance than anything else, all of the advertising, all of the advocacy or anything, it's the argument that the proponents made and put before the voters in the hands of every single voter. I submit that that is the kind of discriminatory animus. I'm not projecting an evil motive. I'm simply saying, when you're projecting on a group of people that they are different, and you don't want your children to know about them, you certainly don't want your children to think that they are normal, that is what animated Proposition 8. And that's the best evidence of it. Now, the trial. The trial, we relied on a definition of marriage, as I pointed out, that was supported by 14 Supreme Court decisions. I've said them over and over again, privacy and association and liberty and that sort of thing. Mr. Cooper has been mentioning some appellate court decisions. With all due respect, the 122-year history from the United States Supreme Court outweighs that. We have the evidence of the plaintiffs and some other witnesses during the trial talking about what marriage meant to them and what it meant to be denied marriage. That was pretty powerful evidence. We didn't have anything on the other side. And then we had 8 witnesses who are experts, the best ones we could find in the world on the history of marriage. Marriage itself, the stigma caused by discrimination, the emotional damage caused by discrimination on the basis of sexual orientation. Immutability, we had all kinds of evidence about that. I don't know how my opponent can stand up in here and say that there was evidence on the other side. There wasn't evidence on the other side. He said it's a matter of choice. Well, it is not a matter of choice. Some people may change, but it is a sexual identity that most people have or don't have one way or the other. And the experts testified that it wasn't an immutable characteristic. And political power, anyway. That was all the evidence in this case. Supreme Court decisions, testimony by the people affected by Proposition 8, and 8 of the leading experts in the world. And then there was Mr. Blankenhorn, who really sort of came over to our side. But on the other side of that, if you discount Mr. Blankenhorn, there is nothing. This is a trial where all of the evidence was supported on one side. With respect to immutability, Mr. Cooper quoted the high-tech gay case from the Ninth Circuit. I must have heard that phrase 6 or 8 times during his closing argument. The high-tech gay case was in 1990, I think it was. It was. It relied on Bowers v. Hardwick, which the Supreme Court specifically reversed and overruled. Bowers v. Hardwick isn't anything that you can rely on in the Ninth Circuit or anywhere else. The high-tech gays case was superseded by Hernandez v. Montreal, which is a 1999 decision. And on page 1093, I'll just read one sentence. Sexual orientation and sexual identity are immutable. They are so fundamental to one's identity that a person should not be required to abandon them. That, if we're going to have a Ninth Circuit precedent, would be the guidance for your honor. That's the case. The standard of review, I think, I will skip that over. I think it's important for me to finish to talk about what is happening here. What is happening here, and it affects the standard of review because we think it's the court's strict scrutiny or level of higher scrutiny. You asked Mr. Cooper the question, isn't it a gender-based distinction? And he acknowledged that it is. Your choice of your marital partner is dependent upon their gender. A certain number of people are disqualified from your freedom of choice because of their gender. That's gender discrimination. And the choice of gender is driven by sexual orientation, so it's discrimination on that basis. And it does have to do with if you believe that it's a fundamental right to marriage, not fundamental right to be married in June or fundamental right to be married to certain types of people. If it's a fundamental right to marriage, it's strict scrutiny. But in any event, you have to have a reason. And you have to have a reason that's real. Not a post hoc justification, not speculation, not built on stereotypes, and not hypothetical. That's what the Supreme Court decisions tell us. And we don't have that here. We have a decision that takes, and there isn't any question, a group of people who have been victims of discrimination, who are a discrete minority, who have identifiable characteristics, their sexual orientation, and we want to foreclose them from participating in the most fundamental relationship in life? Now, rational basis, strict scrutiny, or some kind of intermediate scrutiny tells you those are basic facts. You are discriminating against a group of people. You are causing them harm. You are excluding them from an important part of life, and you have to have a good reason for that. And I submit, at the end of the day, I don't know, and I don't have to put on any evidence, with all due respect to Mr. Cooper, does not cut it. It does not cut it when you are taking away the constitutional rights basic human rights and human decency from a large group of individuals. And you don't know why they are a threat to your definition or of a particular institution. The combination, as I said before, of those 14 Supreme Court decisions, that tell us how valuable marriage is. The Romer case says that you can't take away rights and make them unconstitutional to impossible to recover except by amending your state constitution, and the Lawrence case that says that the sexual orientation of individuals in their private conduct is a protected right. You cannot then, in the face of all those decisions by the United States Supreme Court, say to these individuals, we are going to take away the constitutional right to liberty, privacy, association, and sexual intimacy that we tell you that you have. And then we will now use that as a basis for not allowing you the freedom to marry. That is not acceptable. It's not acceptable under our Constitution. And Mr. Blankenhorn is absolutely right. The day that we end that, we will be more American.
Very well. Thank you, Mr. Olson. And with that, the matter will be submitted. Thank you very much, counsel. I appreciate the advocacy on both sides. It's been splendid, both the written advocacy, oral advocacy, and the presentations that you've made. So if there is nothing further, Mr. Cooper?
No. No, Your Honor. Thank you so much.
Very well. The matter is submitted.
Thank you, Your Honor.